Good afternoon, Ms. Williams. Ma'am, you were arrested on a warrant issued by Judge Savage for failure to appear at arraignment on a driving while license revoked charge. Tell me about your ability to post bond.
Well, I don't have any. I called a couple bail bondsmen, but they said since it was a failure to appear, they didn't want to touch me. But I do get paid on Friday. Won't be that much, but
You have family who can help you come up with some money?
no, sir. My dad and mom passed away, and my sisters don't want to help.
All right. Judge Savage set a $2,000 bond, which I tell you what I'm going to do. I'm going to reduce the bond. If you've not been able to get a bond surety. I'm sorry?
I'm not going to be able to make bond.
Well, what I'm going to do is I'm going to reduce your bond to $200. That's what you'd be paying if you got a bond.
But I don't got it.
Well, that's all I can do since it's a failure to appear, but it was 2,000. I'm going to reduce it down to 200. And hopefully you'll be able to come up with something. Otherwise, the public defender can file a motion for you and try to get, I believe it's Judge Sanders now, but Judge Sanders can hear your case and address the issue of bond, okay?
All right.
All right, thank you, ma'am.
Next court date, if still in jail, January 13th at 8:05 a.m., courtroom 4A. If released, January 31st at 8:15 a.m., courtroom 4A.
All right, thank you. Next case will be 22MM1. James, is that Blur or BLU? I can't, BLUA?
Here's Lewis, sir.
Blua, okay. All right, good morning or good afternoon, sir. All right, Mr. Blua, you were arrested for the charges of petty theft, first offense, and resisting an officer without violence. I do find probable cause after reviewing the arrest affidavit. You're qualified for pretrial release. So I'm going to reduce your bonds to pretrial release conditions, and they will instruct you there at the jail what those conditions are and how you'll go about complying with those. If you violate those conditions, you'll be back in jail. You understand that?
I do, Your Honor. Yes, sir.
All right. Counsel, anything else on Mr. Blua's case?
Nothing from defense, Your Honor.
Nothing from the state, Your Honor.
All right, thank you. Next case, I believe he bonded out. Matthew Demio, 22 CF1. Is that correct? All right. 22 MM2, Andre Dimitrescu?
He's present under
Yeah,
motion, Your Honor.
okay, thank you, sir. All right, I believe we have a witness here on this case. All right, so I've reviewed the affidavit of arrest. I do find probable cause. There is no bond at this point, so I need to hear from the alleged victim. Good afternoon, sir. Raise your right hand to be placed under oath, please.
Good afternoon, Your Honor.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, so I've read the affidavit, sir, and I see that you declined prosecution at the scene and refused to write a statement. So I'm aware of your position, but the state has the ultimate filing authority. So tell me what you want me to consider with regard to terms of release and things of that sort.
Your Honor, Andre is my son. We were born in we have the same birthday. He was a wonderful child until high school. He started using marijuana. He was minor. I couldn't do anything. I called the police a few times. I couldn't do anything. And since then, since he was 16, he was having problem with smoking, either drugs or cigarettes. I made clear in my house, no drugs, no sex, no smoke, no alcohol, like any other parent would do. And I never did drugs in my life. I smoked once in a blue moon a cigar. They saw me. My wife was she had a health problem for many, many years. That problem, then she had a surgery. While she had this problem, she was in a terrific pain, and she was administered all kind of heavy medicine. So the kids, they saw it, what she's been through, what we've been through. Now, I'm thinking he was diagnosed with ADHD, as well as my older daughter, and he started doing Adderall, I think it's called. And then when he started doing marijuana, I did some research and I explained to him, listen, you do these two things, it's gonna fry your brains. You're not gonna be able to think straight. And I had the discussions for at least 5 years with him. Now,
So, and I understand all that, but so tell me, right now he's in jail, there's probable cause for his arrest. He has violated his probation in another case by getting arrested, so I have to address that as well, but he is entitled to bond on this new charge. So are you, where's he going to live, and are you
he's gonna
afraid
live
of
with
him?
me. I'm gonna continue to monitor him. He needs help, he needs mental evaluation, he needs rehab. He stays clean from drugs. He's been appointed to go to see the officer every month, and he did a test, drug test, and he came clean. His problem is not doing what I'm telling him. No cigarettes in the house, no smokes in the house. He has these problems because of his ADHD. He's not violent at all. He's just trying to hide his stupid mistakes, but he's not violent. He's never been violent. And when you try to hide something, you become bully kind of. And I told him, listen, just calm down. We're gonna go to this problem. And he's lying a lot of times because he's doing stupid things which are not allowed in the house, but I'm strong enough to keep an eye on him. I'm the opposite of my wife. She trusted them 100%, and I said, okay, you trust them, but you have to check on them. You have to verify on them. She
Who is
doesn't
this,
want-
your wife?
I'm sorry?
Is this your wife you're talking about?
No. His mother.
His mother, okay.
Yeah. So, as a family, father and mother with the children, we have two different opposite approaches on our children. I keep an eye on them, I verify them, she trusts them. And this is where they are confused. And this is what leads to the situation he is now.
Okay.
He is not violent whatsoever.
All right, so thank you, sir. So with regard to this new case, I'm going to, he doesn't qualify for PTR, so I'm going to set bond in the new case at $500 with conditions that he may have no hostile contact with the alleged victim. He may reside with the alleged victim as long as there's no hostile contact, may not possess any weapons or firearms, may not use drugs or narcotics without a valid prescription. Those are going to be the conditions of the bond. In case number 2021 CF 1002, sir, you're on probation in that case. I'm going to find an on-view violation of probation based on the probable cause in this new case. You're going to be held without bond in the probation case. You'll have to have your attorney take your case before the presiding judge to see if you can get a bond or resolve that violation of probation.
But they told me they're not going to violate my probation.
I just told you you did. I made that finding, all right?
I didn't hurt my father.
Sir, we're not here to talk about that, okay? So your attorney will visit with you about what will be happening next. It sounds like you need some help, and maybe this is a good opportunity for you to come to terms with that.
I was about to enroll in counseling in a few days.
All right.
I was just about to enroll in my counseling.
Your attorney will be visiting with you about that, sir. Counsel, is there anything else we need to address?
Nothing from defense, Your Honor.
All right, state. Okay, thank you, sir.
So I can't.
Okay, Amber Fountain, 22 CF2.
Your Honor, I've been informed that she is still in medical and is unable to be moved at the moment. We'd be asking for a 24-hour reset in this case.
Okay, she's at the hospital.
I believe she, yes, sorry, yes, the hospital, Your Honor.
Okay. All right, so we'll reset Ms. Fountain for tomorrow. The next case is 22MM3, Paul Gabrishki. I apologize for mispronouncing that.
Everybody messes that up.
Okay.
11 letters is kind of hard to
All right, tell me how to pronounce your name, sir.
Gadershevsky.
Gabrishevsky, okay. Thank you. All right, so I have reviewed the affidavit of arrest. I do find probable cause. This is a little bit complicated situation, and I appreciate you being here, ma'am. Would you raise your right hand to be sworn, please?
Do you solemnly swear or affirm that the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, for the record, would you state your name, please?
Judith Mellon.
Okay, Ms. Mellon, so tell me what you want me to hear.
Paul isn't a resident at the assisted living that I am the administrator for. It is a limited mental health assisted living. So everyone there has a mental diagnosis. It's holiday time. They're all on edge. And so he's actually one of my real good residents who are no trouble. Must have got intoxicated and the trouble came. The person he had the altercation with, on the other hand, does have trouble. So I'm just here to say that he abides by everything at the community with the exception of alcohol. But it wasn't on the premises, it was alcohol on the outside, so therefore I can't do anything about his living situation. But he does live there, he's a total Medicaid recipient, he doesn't have any funds, and that's it.
Okay, let me ask you some questions. So, in this sort of case, typically the court would order no contact, which would mean maintain a separate residence, which would mean he couldn't return there. But based on the circumstances you're describing, don't know what the alternative would be. So how close does he reside to the alleged victim?
They're on the same floor and on same floor, opposite sides of the building. It's Greenleaf right behind the police station there, so it's that old hospital. So it's pretty big, but, I mean, they're on the same floor. They don't eat at the same time, so
Is there a history between them, or is this a one-time?
This was a one-time thing. Actually, Paul's is in his room unless he's smoking. Other than that, he doesn't really, and he stays in his room and he draws.
Okay. Defense, what would you like to say with regard to release terms?
Your Honor, just, we would request, based on the testimony that we've heard today, since there are no other viable options, that we be allowed him to return and not have to maintain a separate residence at this time. And we'd request no hostile contact with the alleged victim.
All right. State?
The state would also request no hostile contact.
Okay, thank you. This to me is kind of like someone living in the same apartment complex. They don't live in the same room, and the room is their residence, right?
Right.
All right, so you qualify, sir, for direct pretrial release. So I'm going to reduce your bond. Well, I guess I'm setting your bond. No, you have a $500 bond. So I'm reducing your bond to pretrial release conditions. They'll instruct you on those conditions at the jail before you're released. I'm going to allow you to return to your residence at Greenleaf, subject to no hostile contact with the alleged victim in this case. So that means just avoid them, okay?
Yes, sir.
Any other conditions, state?
Yes, Your Honor, the state would also request no alcohol.
I have that written in my notes, but I'm wondering how we would enforce that.
I'm not entirely sure, Your Honor.
Yeah, I mean, I would love to do that, but I think under the totality of the circumstances, there's no sense to order something that would be a big
He's
deal.
been in rehab before.
I'm sorry?
He has been in rehab before coming to me.
Okay,
He's been pretty clean.
yeah. All right. Well, if he's been pretty clean, why don't I then go ahead and order, sir, that as a condition of your release, you not consume any alcohol or any drugs or narcotics without a prescription. If you violate that, that could land you back in jail. Okay?
I heard that. Yes, sir.
All right. Okay, thank you, ma'am.
Thank you.
All right, 22 CF3, Tyrone Jurilal.
Present and approaching, Your Honor.
Good afternoon, sir. So you were arrested on the charge of criminal mischief of $1,000 or more. I've reviewed the affidavit of arrest, and I do find probable cause. I'm going to stay your bond at $2,500 in this case. You're actually out on bond with pretrial release conditions in 2021 MM 2756. Based on this new charge, I'm going to revoke your bond, set it at 0 in the misdemeanor case. It looks like you reside next door to the location of this alleged offense. So I'm going to allow you to return to your home without violating a no contact order, but otherwise you may not have contact with the alleged victims, and you may not go to the address of 2470 Albany Lane. All right, anything further, counsel?
Nothing from defense, Your Honor.
State?
Nothing from the state, Your Honor.
All right, thank you. Next case, 22MM4, Jerry Marlowe.
Your Honor, he is present and approaching. Defense does not have a probable cause challenge on this case, but we do have a request.
Yeah, it's an unusual set of circumstances.
Yes, Your Honor.
Yeah. Good afternoon, Mr. Marlowe.
Afternoon, Your Honor.
Sir, you were arrested for violation of a domestic injunction. I'm aware of the circumstances. And I sort of agree with what you apparently said to the police officers based on what I'm reading. But there is probable cause for the charge. Counsel, what do you want me to consider?
Your Honor, we would be asking that you consider ROR in this case, as the arrest affidavit shows every party involved, including the AV or the person that had the domestic injunction, was okay with the defendant returning to this address. The person who had the injunction no longer lives there, and by her own admission was late on changing the address to her new address. So for all those reasons, we'd be requesting ROR in this case, Your Honor.
It's my understanding he didn't live at that address, he was just visiting and had been invited there.
Yes, Your Honor.
State, do you have any objection to ROR?
No objection, Your Honor.
All right, I'm going to order that you be released on your own recognizance, sir. You still may not have any contact with, is it Miss Strange? Is that her name? So you still may have no contact with her, but she's not residing at that residence any longer, and you were invited there. I would suggest you not return to that residence until that injunction is modified, so you don't pick up another charge. All right, everyone thought they knew what they were doing, but the technicalities, I think, tripped everyone up. All right. So ROR, and I've already addressed counsel, appointment of counsel and all that. Anything else, counsel?
Nothing for defense, Your Honor.
All right, thank you.
Nothing from the state.
Appreciate it. Timothy Monday, 2022 MM5.
Your Honor, I've been informed that Mr. Monday is currently tested positive for COVID and is in quarantine. We'll be requesting a reset for within 24 hours of his release from quarantine.
When did he test positive?
Yesterday.
Yeah,
He might be in quarantine for some time.
right. If he just tested yesterday, he's,
I believe that's what occurred, Your Honor, so it
All right.
might be a while, yes.
so do you want to waive?
Yes, Your Honor, in that case, we would waive.
All right, so we'll waive his appearance based on counsel. He was arrested for trespass on property other than a structure or conveyance. His bond is $150. He does not qualify for pretrial release. Is that because of what he tested yesterday or for other reasons?
Yes, Your Honor. And he does have extensive history dating back to 1989,
Okay.
including out of state.
All right, well, the 150 bond is a reasonable bond. So I'll set that, I'll leave that in place with the condition that he not return to Old Town, 5770 West Earl Bronson Memorial Highway in Kissimmee. All right, and I've already addressed appointment of counsel and such. Anything else, counsel?
Nothing from defense, Your Honor.
Thank you. James Moore, 2022 CF4.
President approaching, Your Honor.
Good afternoon, Mr. Moore. Mr. Moore, you were arrested on the charge of robbery armed with a deadly weapon. I reviewed the affidavit of arrest, and I do find probable cause. You don't have a bond in this case. And I need to set one. State, what's your position?
Your Honor, at this time, the state is requesting that no bond, the defendant be held at no bond. There is proof evident and presumption great of this crime. There were two witnesses who observed this crime, and there is a video of the defendant walking out of the store with a knife. As this is a first-degree felony robbery, the state would be requesting no bond.
All right, defense, your response to that?
Your Honor, we would be requesting a reasonable bond be set in this case, unless Your Honor is finding proof evident presumption great within the four corners of the charging affidavit. I don't think we've been noticed for a hearing on that matter today, and we would request, and because of that, that a reasonable bond be set in this matter.
Yeah, I think the Supreme Court is still considering whether the proof evident presumption great has to occur at first appearance or can be determined later, aren't they?
I believe that is the case, Your Honor.
Under the pretrial detention statute, if I make a probable cause finding, the state then has a period of time in which to file a motion for pretrial detention. And I don't know why the same wouldn't apply to the state pursuing proof evident presumption great finding through an Arthur hearing in the division. So I'm going to order that Mr. Moore be held without bond in order for the state to tee up either a pretrial detention motion or an Arthur proceeding before the division judge. But that needs to be done within the time frame required by the pretrial detention statute. All right, and then sir, you're out on release in case number 2021 CF 3412. That's also an aggravated assault with a deadly weapon charge. Based on the probable cause finding in this case, I'm going to revoke your ROR in order that you be held without bond in that case. Okay, I've addressed the appointment of counsel already. Is there anything else I need to address, counsel?
Nothing from the defense, Your Honor.
All right, state?
Nothing from the state, Your Honor.
All right, thank you. Thank you, sir. 2022 MM6, James Walters.
President approaching, Your Honor. Counsel will have argument in reference to this case.
Okay. And we have the alleged victim here as well. Good afternoon, sir. You were arrested, sir, on the charge of battery, domestic violence, and counsel, you can proceed with your argument.
Yes, Your Honor. Turning to the end of this arrest affidavit, we are told that the AV wished to withdraw her initial statement and stated directly to police officers that it was all a lie. It seems that she did this when the gravity of the situation hit her, instead of the police just coming to break up any possible altercation, we're going to arrest somebody. Based on that, I would say this arrest affidavit lacks probable cause because we can no longer be sure which was correct, the time that she told the story about what happened or the time that she admitted to the officer that she was lying.
All right, and State, do you want to respond to that?
Yes, Your Honor. It is, and the officers in this case had the duty of making a determination as to the credibility of any witnesses and what the officers believed at the time happened. In this case, the victim claimed that she was battered, and officers who were there at the time were able to assess the scene, determined that the victim, that they believed the victim's statements when she claimed that she was battered, and did not believe the victim's statements when she advised that what she had previously said was a lie. And for that reason, the state would request that Your Honor find probable cause.
All right. Raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. State your name and spell it for the record, please.
Carla Craig, C-A-R-L-A-C-R-A-I-G.
All right. Thank you, Ms. Craig. So you've heard the arguments of the attorneys, and I was familiar with the circumstances that the defense argued. Tell me what you would like for me to consider with regard to terms of release for Mr. Walters.
I would like for him to be released. What happened that evening? At the time it happened, I was so angry over what had happened. I mean, it happened just like that in a snap. I didn't realize anything that was going on. I honestly, at the time, thought he did that. But once I was able to calm down and start thinking straight, I realized that he probably did fall. He was behind me, and he doesn't walk very well. He's very unstable on his feet and his legs. And there's a lot of times that he holds on to me when we're walking someplace. So when it happened, it doesn't surprise me if he did fall, and I'm sure that he did fall. When I told the officers not to arrest him, the officer asked me if I was lying. I didn't tell him I was lying. I didn't answer the question because I couldn't get anything to come out of my mind. It was just blank. I couldn't speak for some reason. And I know that he did not do this intentionally. Cash and I lived together, we worked together.
10 years, it said, right?
Yeah.
So did you tell the officers you would be willing to go to jail instead of him?
Yes, I did.
Are you afraid of him?
No.
And do you have any concerns with him returning to the home?
I have no concerns with him returning to the home.
Are there any weapons or firearms in the home?
No, sir.
All right. Based on what I read in the affidavit, based on Ms. Craig's testimony today, and based on the arguments of defense, I am going to find a lack of probable cause. Well, let me change that. I think there was probable cause when the police made the arrest. Based on what they knew at the time, I think there was probable cause. I think in hindsight, we know a little more. But based on those circumstances, I'm going to order that Mr. Walters be released on his own recognizance. And I'm going to order that he have no hostile contact with Ms. Craig. That means you may live together, sir, but you may not have any hostile contact, meaning no insults, no yelling, no physical altercations. I'm going to order no weapons or firearms. You may not possess any weapons or firearms, and you may not use any drugs or narcotics without a valid prescription, and no alcohol. You're not going to be subjected to random urinalysis, but if you are found to be using any of those substances or intoxicants while the case is pending, you could land back in jail. Okay? All right. Thank you.
Thank you. When can I pick him up?
I mean, you can go out there now, but I don't know how long it takes them to process them, but I released them on non-monetary terms.
Okay, thank you.
It's still going to be a couple hours.
All right, so Fabian Wiggins, 2022 CF5.
President approaching, Your Honor.
Judge, or, PC or no PC?
Is PC, but released ROI.
Okay, thank you.
I waffled on that one. All right, Mr. Wiggins, good afternoon, sir.
Afternoon.
So you were arrested for resisting arrest without violence and possession of cocaine. I reviewed the affidavit of arrest. I do find probable cause. You qualify for direct pretrial release, so I'm going to reduce your bonds to pretrial release non-monetary conditions. Okay, they'll instruct you there at the jail what those conditions are. If you violate those conditions, it'll land you back in jail. Okay. And you'll have to appear for all of your court dates and such as well. Okay. I've already addressed appointment of counsel. Is there anything else we need to address, counsel?
Nothing from defense, Your Honor.
All right, state.
Nothing from the state.
All right, thank you, sir.
Appreciate it.
All right, Donald Berry, 2022 CF6. I believe Mr. Berry is our last.
He is present and approaching, Your Honor. For the court's information, counsel will have a PC argument on this and a request.
Okay. Good afternoon, Mr. Berry. All right, so you were arrested on the charge of aggravated battery on a person 65 years of age or older. And counsel apparently has a probable cause argument and a request. So go ahead.
Yes, Your Honor. This was charged under Florida Statute 784.08-2A, which requires great bodily harm or disfigurement. I don't find either when I read the arrest affidavit. There was some bleeding from the head and a minor laceration. It also requires that the AVs in the case be 65 years or older. My reading of the affidavit shows no proof that the AV was 65 years or older.
Okay, State, do you want to be heard on those?
Your Honor, the state would ask that Your Honor find probable cause for a battery. State also does not find any indication inside any indication that the victim was 65 years old or older.
And what about the aggravation aspect of it? Pushed into a pool, what's your position on that?
There is a serious danger when someone is pushed into a pool, and the officers who responded to the scene were able to see, I believe, a laceration on the defendant's head, if I recall correctly, bleeding from his head, and a minor laceration on his left arm.
All right, what was your request, counsel?
Request would be, Your Honor, it's come to my attention that Mr. Berry has a Baker Act hold out of Park Place, so we'd be requesting ROR or any interim conditional release so that he may be taken to Park Place and given the treatment he needs.
Okay, State, what's your position on that?
The state would simply ask for a reasonable bond and no contact and no return with the victim. Or, excuse me, no contact with the victim and no return to the scene.
Counsel, so my concern is this: if I grant ROR and the Baker Act process runs its course, where does Mr. Berry live? I don't have a victim here.
May I have a moment to confer with my client, Your Honor?
Sure.
Your Honor, the client has informed me that he is currently living with his mother and would be welcome to return there upon release.
Well, I don't have anyone, that's the problem, I don't have anyone here to say that.
Yes, Your Honor.
So, and he apparently has a status that affects where he can live, right? Ms. Hill,
Yes, Your Honor.
Officer Hill, rather. So this is another set of unusual circumstances. And you all have not been able to make contact with the alleged victim, Officer Hill, is that right?
That's correct.
All right, counsel, one last question for you. If I place a bond and conditions, are you suggesting that I can conditionally release so that he can go get treatment and then be returned to the jail unless he posts bond?
Yes, Your Honor. I would believe that would be a step we could take, but defense would be arguing for ROR first.
Your Honor, the Park Place is an unsecured facility. We are not able to send a man to sit on him to ensure that he is brought back to the jail upon release. So there would not be a guarantee that he would return to the jail upon his release from Park Place.
Your Honor, for the court's information, I have handled Baker Acts a couple times on behalf of the Public Defender's Office. I do not know what their procedure is, but we do have to inquire as if there's a jail hold at Park Place. So I do believe they would at least be able to facilitate that somehow.
All right. State, you want to be heard on those?
Nothing from the state, Your Honor.
All right. So this is an unusual set of circumstances. I'm concerned about having ROR just because I don't have an alleged victim saying that Mr. Berry is welcome back in the home. But I also don't want someone who needs mental health treatment languishing in the jail. So I am going to order that Mr. Berry be held on $5,000 bond with conditions of no contact with the alleged victim, no return to the residence except one time with law enforcement to obtain personal belongings. May not possess any weapons or firearms. And I am going to also order that Mr. Berry be conditionally released to the custody of Park Place, subject to a jail hold. And that he comply with all recommended treatment and all evaluations requested and recommended by Park Place. All right, I don't know how that's going to work in the real world, but my intent would be that if Mr. Berry is not returned to the jail after Park Place, that he has not posted bond, he would be subject to being picked up and returned to the jail.
Thank you, Your Honor.
All right. And if anyone has any more specific information for future reference, I'm all ears and would be happy to share it with other judges as well. All right, anything else at the jail, counsel?
I do not believe so, Your Honor.
All right, State.
Nothing from the state.
Okay, thank you, Officer Hill.
Thank you, Your Honor. You enjoy the rest of your day.
All right, you guys too. Have a great day.
Thank you, Your Honor.
We'll be adjourned.
Okay, good morning. I'm Judge George, and I'm here for the purpose of conducting the first appearance calendar. There are a few things I need to go over with you prior to beginning the calendar, so please listen carefully, as this will help you to have a better understanding of the nature of today's proceedings. I'm not here to try your case this morning or take a plea in your case. Instead, I'm here to determine whether you'll need the assistance of an attorney to tell you what you are charged with, whether a bond has been set in your case, and if so, how much that bond is, and to advise you of your next currently scheduled court date. Some of you will have unrestricted bonds, which may be cash, commercial, or property bonds. If you post a cash bond, you'll deliver the full amount in cash to the sheriff of this county, who will hold it until your final court date and then return those monies to you. If you post a property bond, you'll need to find someone who has equity equal to 3 times the bond amount that's willing to pledge the deed to that property as collateral for your return. For example, if your bond is $2,000, the property will have to have at least $6,000 worth of equity in it in order to be used to secure your bond. If you go through a commercial bonding company approved by the sheriff of this county, you'll have to pay that company a certain percentage. That percentage is usually around 15%, and that percentage will not be returned to you. In the event that you have special conditions on your bond that prohibit you from contacting certain people or going to or around certain places, please understand that I do take those conditions very seriously. And if you were to violate the court's order, you could be charged with aggravated stalking. I want you to be aware of certain rights you have. You have the right to remain silent. Should you give up your right to remain silent, any statement you make may be used against you as evidence at any hearing or trial. You have the right to indictment by grand jury for most felonies and by accusation for misdemeanors. You have the right to a speedy and public trial by jury. You have the right to be represented by an attorney. If you cannot afford to hire an attorney, you can ask the court to appoint one for you. For those of you who are charged with misdemeanors only, I want you to listen to me carefully, because I get this question a lot once you come up and I give you your bond. So please listen right now. If you are charged with misdemeanors, you'll have the option to waive your preliminary hearing. What the preliminary hearing does is it establishes probable cause as to whether your case should be bound over to state court. You can waive that preliminary hearing and you can just go ahead to state court to resolve your case. And it just speeds up the process if you'd like to do it that way. You do not have to do it that way. And if you bond out, you will automatically waive your preliminary hearing. So I'm going to begin calling you up individually. I'm going to just inquire as to the deputies whether you would rather start with the women or the men.
The females, Your Honor.
Okay, well, I'll start with the females.
And Your Honor, you're gonna do the fugitives last?
I only have, how many? I have one.
One female, one male.
Yeah, I'll do the, when I do the females, I'll do the fugitive on that side, and then I'll do the fugitive last for the males on that side. That makes sense?
Or do you wanna do the last female and the fugitive male together?
I think it will, see, if I go ahead and do the female now, you can just take all the females back, and then
Okay.
I'll deal with the males.
Okay.
Okay, all right. What's your name, ma'am?
Connor Edwards.
Edwards?
Yes, ma'am.
I don't have, wait a minute. Are you listed as a
Oh,
Corey?
yes, they put me in as Corey instead. That's my middle name.
Okay, okay. Give me just a second. Let me pull your paperwork. I had it in another stack.
Okay.
Okay. Ms. Edwards, you are charged with simple battery, in which your bond is $2,500. You're also charged with simple assault, in which your bond is $2,500. So you have a total bond of $5,000. You have special conditions that you're to stay away from them Williams. You can't return to 1005 South Lake Cove Court, Clayton County. You must not violate any laws while out on bond. I've indicated on your bond order, ma'am, that you can make an appointment with the sheriff's office within 10 days of your release to go get any personal belongings that you have at that location. You do not qualify for a court-appointed attorney, so you will have to hire your own attorney. You're charged with misdemeanors, ma'am, so you have the option of waiving your preliminary hearing. Would you like to waive your preliminary hearing?
No, ma'am.
Okay. Your preliminary hearing is going to be on February the 15th at 8:30 a.m. via Zoom. Thank you, ma'am.
Quincy Lee.
Okay. Ms. Lee, you're charged with battery. Your bond is $5,000. Disorderly house, $1,000. Terroristic threats, $10,000, and DUI, alcohol less safe, $5,000. You have a total bond of $21,000. You have special conditions to stay away from Anderson Osborne. You must not violate any laws while out on bond. You have a preliminary hearing scheduled for February the 14th at 8:30 a.m. via Zoom. And ma'am, you indicated that you have a job, but you didn't indicate how much you make per month. How much do you make per month?
2,100.
Okay. All right. So you do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. Thank you.
Thank you.
You're welcome.
Lauren Shay Shaw.
Okay. All right, Ms. Shaw, you're charged with simple battery. Your bond is $2,500. You have special conditions to stay away from Sierra Robertson. You must not return to 746 Garden Walk Boulevard in Atlanta. You must not violate any laws while out on bond. I've indicated on your bond order that you can make an appointment with the sheriff's office within 10 days of your release to go get any personal belongings that you have at that location. You do qualify for a court-appointed attorney, so I am appointing an attorney to represent you. Do you wish to waive your preliminary hearing?
No.
Okay, your preliminary hearing is going to be scheduled for February the 15th at 8:30 a.m. via Zoom. Thank you, ma'am.
Thank you.
You're welcome.
Brittany Sanchez.
Okay. All right, Ms. Sanchez, you are charged with simple battery. Your bond is $2,500. You have special conditions to stay away from April Lawrence. You must not violate any laws while out on bond. You do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. Do you wish to waive your preliminary hearing?
No, ma'am.
Okay, your preliminary hearing is scheduled for February the 15th at 8:30 a.m. via Zoom. Thank you, ma'am.
Thank you.
You're welcome. What's your name, ma'am?
Martisha Smith.
Okay. Ms. Smith, you're charged with criminal damage to property in the second degree. Your bond is $6,000. You must not violate any laws while out on bond. You have a preliminary hearing scheduled for February the 16th at 8:30 via Zoom. And how much do you make per month, ma'am? I can hardly read it on your form. Is it 3,000?
2,000.
2,000, okay. So you do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. Thank you, ma'am.
Thank you. Shania Dixon.
Say your last name again?
Dixon.
Sigpen, okay. Okay, Ms. Thigpen, you're charged with use of possession of drug-related objects. Your bond is $1,500 on that charge. Driving with expired or invalid tag, $500. Use for concealing identity of a tag, $500. Improper lane change, $500, and no tail lights, $500. You have a total bond of $3,500. You must not violate any laws while out on bond. You indicated that you work, Ms. Thigpen, but you didn't say how much you make per month. How much do you make per month?
About 1,800.
Okay. You do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. Do you wish to waive your preliminary hearing?
Yeah.
Yes, okay, thank you.
Thank you. Shaquanda Harris.
Okay. Okay, Ms. Harris, you don't have any charges pending against you here in the state of Georgia. You've been brought before the court today because you have charges pending against you in another state, that state being Texas, and they are requesting your return. Because you are wanted by another jurisdiction, I'm not allowing a bond at this time. If you decide to contest extradition, you'll be committed to the Clayton County Jail for an initial period of 30 days. During this time, a warrant will be prepared under the governor's signature for your extradition to Texas. The court may, if you do not wish to voluntarily return to Texas, you may file a petition for a writ of habeas corpus to contest extradition. The petition may only contest 4 things, and that's whether the extradition documents are in order on their face, whether you are charged with the crime that actually exists in the demanding state, whether you are the person in the request for the extradition, and whether you are in fact the fugitive from justice. You cannot contest the issue of innocence or guilt for your extradition. If you decide to voluntarily waive extradition and return to Texas, Texas will have up to 30 days to travel here to transport you back. If they don't come and get you within those 30 days and they don't request another 30 days, you will be released. Ms. Harris, would you like to waive extradition and return to Texas?
Yes.
Okay, thank you.
That concludes the females, Your Honor.
Okay, thank you.
Acquit Balayan.
Okay,
Acquit Balayan.
I see. Okay, give me just a second. Let me switch over to the men. Okay, sir. You are charged with theft by taking. Your bond is $2,000. You must not violate any laws while out on bond. Do you work, sir?
Yes.
Okay, and how much do you make per month?
2,000.
2,000, okay. You do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. Do you wish to waive your preliminary hearing?
I want to wait with the preliminary hearing.
You want to waive?
No, I'm not.
Okay, all right, your preliminary hearing is scheduled for February the 15th at 8:30 via Zoom.
Okay.
Thank you.
Thank you. Have a seat back there.
Clifford Daniel.
Okay. Mr. Daniel, you're charged with possession of marijuana less than an ounce. Your bond is $1,500. You must not violate any laws while out on bond. Do you work, sir?
Yes, ma'am.
How much you make per month?
I good 22.
I'm sorry,
22.
22 or 27?
22.
22, okay. You do not qualify for a court-appointed attorney, so you will have to hire your own attorney. Do you wish to waive your preliminary hearing?
You say what?
Do you wish to waive your preliminary hearing?
No, ma'am.
Okay, your preliminary hearing is scheduled for February the 15th at 8:30 via Zoom. Thank you.
Have a seat back there. State your name. Roger Brooks.
Mr. Dukes, you are charged with rape, sodomy. Let me go back and tell you the bond for each one. Rape, you have no bond under 1761. You cannot have a bond for that charge granted by me today. Sodomy, no bond denied. Sexual battery, which is your only misdemeanor, you have a $6,000 bond. Cruelty to children in the first degree, no bond denied. And incest, no bond denied. You have special conditions that you're to stay away from Jakia Lyons. You cannot return to 157 Indian Lake Drive in Morrow. You must not violate any laws while out on bond. I've indicated on your bond order that you can make an appointment with the sheriff's office within 10 days of your release to go get any personal belongings you have there. Sir, you also must not have any contact with any children under the age of 16 years of age without an adult present that's 21 years of age or older. Do you understand that?
Yes, ma'am.
You have a preliminary hearing scheduled for February the 14th at 8:30 a.m. and a bond hearing scheduled with the Superior Court for February 18th at 8:30. Thank you.
Good morning, Marquise Johnson.
Okay. Mr. Johnson, you're charged with red light violation, $500 bond, wrong side of the road, $500, improper lane change, $500, improper turn signal, $500, DUI, alcohol less safe, $5,000, and driving on a suspended license, $1,500. You have a total bond of $8,500.
Yes, ma'am.
You do qualify for a court-appointed attorney, so I am going to appoint one to represent you. You must not violate any laws while out on bond. Do you wish to waive your preliminary hearing, sir?
No, ma'am.
Okay, your preliminary hearing is scheduled for February the 15th at 8:30 a.m. via Zoom. Thank you, sir.
Timothy Johnson.
And Mr. Johnson, you are charged with aggravated assault by strangulation, in which your bond is $15,000, including the children in the first degree, your bond is $10,000. You have a total bond of $25,000. You have special conditions that you're to stay away from Tamia Raynell Johnson. You can't return to 501 Roberts Drive, apartment 54 in Riverdale. You must not violate any laws while out on bond. I've indicated on your bond order that you can make an appointment with the sheriff's office within 10 days of your release to go get any personal belongings you have there. So you don't qualify for a court-appointed attorney, so you will have to hire your own attorney. Your preliminary hearing is scheduled for February 14th at 8:30 a.m. via Zoom. Thank you.
Thank you.
You're welcome.
Come on, Joe. State your name. State your name.
Deontay Johnson.
Okay. Mr. Jones, you're charged with violation of the Georgia Controlled Substances Act. Your bond is $6,000 on that charge, driving with no insurance, $1,000, and driving with no tag or expired or invalid tag, $500. You have a total bond of $7,500. You must not violate any laws while out on bond. You have a preliminary hearing scheduled for February the 14th at 8:30 via Zoom. And you do qualify for a court-appointed attorney, so I am going to appoint one to represent you. Thank you, sir.
State your name.
Okay. Mr. Real, you're charged with possession of a firearm by a felon. Your bond is $10,000. You must not violate any laws while out on bond. You have a preliminary hearing scheduled for February the 14th at 8:30. You do qualify for, well, actually, you didn't indicate how much you make per month. How much you make per month?
This fluctuates between 18 and maybe 20, maybe 2 grand, 1800, 2 grand. I run a movie club.
Between 1,800 and 2 grand? Is that right?
Yes, ma'am.
Okay, all right. You do qualify for a court-appointed attorney, so I am going to appoint one to represent you. Your preliminary hearing is February 14th at 8:30 via Zoom. Thank you, sir.
Richardson.
Are you Mr. Richardson? Are you Mr. Richardson?
Yes, ma'am.
Okay, Mr. Richardson, you're charged with a stop sign violation. Your bond is $500 on that charge. Obstructing or hindering the display of your license, $500, and driving with no license, $1,000, for a total bond of $2,000. You must not violate any laws while out on bond. Do you have a job, sir? I can't hear you.
No, and not at this point.
Okay. Well, I am going to appoint an attorney to represent you. Do you wish to waive your preliminary hearing?
Yes.
Okay. Thank you.
Thank you.
State your name.
Hello.
Octavian Robinson.
Octavia Robinson, okay. Mr. Robinson, you're charged with simple battery. Your bond is $3,500. You have special conditions to stay away from Martavius Young and Kynthia Young. You can't return to 773 Brookwood Drive in Clayton County. You must not violate any laws while out on bond. I've indicated on your bond order that you can make an appointment with the sheriff's office within 10 days of your release to go get any personal belongings that you have at that location. Do you wish to waive your preliminary hearing, sir?
What does that mean, Your Honor?
It's what I explained in the beginning when I told everybody to listen. And I said that you.
We heard you, but it was like some noise in the background, so.
Okay, well, a preliminary hearing is to establish whether there's probable cause to bind your case over to state court. If you waive your preliminary hearing, it just speeds up the process. And we won't have to establish that. You can just go to state court to resolve your case. If you bond out, you will waive your preliminary hearing.
All right, thank you.
Do you want to waive? Or would you like to speak with your attorney first?
Does it cost extra? And can I speak to him first?
Oh, yes. So I'll put you down, and if you want to waive after speaking with your attorney, you can.
All right, thank you.
You're welcome.
State your name.
Boston Rouse?
Boston Rouse?
Yes,
Okay. Mr. Rouse, you're charged with terroristic threats, aggravated assault with a deadly weapon, possession of marijuana less than an ounce. And let me go back and give you the bond for each. I'm sorry. Terroristic threats, $10,000. Aggravated assault with a deadly weapon, $20,000. Possession of marijuana less than an ounce, $1,500. Use of possession of drug-related objects, $1,500. No tag light, $500. And possession of a weapon during the commission of a crime. I am actually going to deny that charge. So you won't have that charge along with the others. You have special conditions to stay away from Darius Thomas, Shannon Kelly, and Tymeria Kelly. You must stay away from 280 Commons Drive in Jonesboro. You must not violate any laws while out on bond. You have a preliminary hearing scheduled for February the 16th at 8:30 a.m. And you do qualify for a court-appointed attorney, sir.
Man, what's the total?
Your total bond is $33,500.
All right, thank you.
Okay, you're welcome.
State your name.
How you doing? My name is Trayvon Teleferro.
Hey, give me just a second, sir.
Thanks for that question.
What she said.
All right, sir. You're charged with battery, family violence. Your bond is $3,500. You have special conditions to stay away from Maya Brown. You can't return to 2070 Lake Harbor Road in Morrow. You must not violate any laws while out on bond. You do qualify for a court-appointed attorney, so I am going to appoint an attorney to represent you. Do you wish to waive your preliminary hearing?
No.
Okay, your preliminary hearing is scheduled for February the 15th at 8:30 via Zoom. Thank you, sir.
Good morning, Your Honor. My name is Wilson Machado.
Okay.
Your Honor, his name is backwards. Wilson is his first name.
Wilson Metellus. Okay.
Good morning.
So you're charged with driving on a suspended license. Your bond is $1,500. Improper lane change, $500. Driving with no insurance, $1,000. And knowingly driving a motor vehicle on suspended or canceled registration, $500. You have a total bond of $3,500. You must not violate any laws while out on bond. You do not qualify for a court-appointed attorney, so you will have to hire your own attorney, sir. Do you wish to waive your preliminary hearing?
No, ma'am.
No? Okay. Your preliminary hearing is scheduled for February the 15th at 8:30 via Zoom. Thank you, sir.
And that's favor situation now.
I'm sorry?
He's trying to ask a favor if he can sign me out. I have no money. I have to get the truck back out now. And yes.
Yeah, I'm not gonna be able to give you a signature bond at this time, but just so you're not, are you working?
Yes and no, because my money is changing because of the weather.
Okay, well, this is what I'll do. I will appoint an attorney to represent you. That way you can speak with your attorney.
There's nothing I could do about you letting me out.
Well, talk to your attorney and maybe they can negotiate something before your preliminary hearing, okay? They'll be there to see you pretty soon in the next few days, okay? All right, thank you.
Come on. All right, state your name.
Timothy Cooper.
All right, Mr. Cooper, you don't have any charges pending against you here in Clayton County. You've been brought before the court today because you have charges pending against you in another jurisdiction, that jurisdiction being South Carolina. As you're wanted by another jurisdiction, I'm not allowing a bond for you at this time. If you decide to contest extradition, you'll be committed to the Clayton County Jail for an initial period of 30 days. During this time, a warrant will be prepared under the governor's signature for your extradition to South Carolina. The court may consider allowing you to post a bond, but the court is not required to do so. As I stated, as you wanted by another jurisdiction, I'm not allowing a bond at this time. If you do not wish to voluntarily return to South Carolina, you may file a petition for a writ of habeas corpus to contest extradition. The petition may only contest 4 things: whether the extradition documents are in order on their face, whether you are charged with a crime that actually exists in the demanding state, whether you are the person named in the request for extradition, and whether you are in fact a fugitive from justice. You cannot contest the issue of guilt or innocence in your extradition hearing. If you decide to voluntarily waive extradition and return to South Carolina will have up to 30 days to travel here and transport you back. If they don't apply to extend that time period, you will be released after 30 days if they don't come and get you. Do you wish to waive extradition, sir?
Yes, ma'am.
Okay, thank you.
I'll get these forms sent that go to you, Your Honor.
Okay, thank you.
All right.